Hi folks, this is John Adamson, the Rehab and Documentation Guru. Day after Thanksgiving. Hope you're having a great day. I'm working, probably like many of you. So last night as I was recovering from my diabetic coma and the kids were in bed, I made the mistake of going onto social media and looking at Facebook. And then, of course, I can't not get involved in conversations, especially when I see people making commentary that's not true. And one particular bit of commentary is that companies are held to different standards legally and ethically than the individual therapist. So let's talk about that for a moment. No, they're not held to different standards. While companies may sometimes get away with things that an individual would not, because obviously there's not a complete lack of corruption. I wish there was in the lawsuits and the powers that be in dealing with individuals versus corporations. Obviously, there's a bit of quid pro quo that goes on. That's another conversation. But for the most part, there is a system in place to make sure that the same ethical and same legal standards applied to individuals as they do to corporations. Now, obviously, we increase the power of the individual by joining together as a collective, and that's where unions come in. But we still have the same responsibilities and rights. I'll give you an example. Rehab Care and formerly Beverley Enterprises both had major lawsuits against them. They're pretty well known, and you can easily Google them. And it was related to overbilling of Medicare. Legal standards were applied to both of these companies, and they were found to be at fault for Medicare fraud. Now, let's talk for a moment about this. This is where the therapist's responsibility and the company's responsibility coincide. They are the same. Who committed the Medicare fraud in this particular case? Well, technically, it was the individual therapist. Because individual therapists, over thousands of therapists, billed Medicare for services that were not medically necessary as defined by things like the RAI manual and Chapter 15 of the Medicare Benefit Policy Manual, Chapter 8 of the Medicare Benefit Policy Manual. I'm talking about SNF and long-term care right now. So anyway, those individual therapists did things they should not have done. But then collectively, because this was a broad-based practice by all therapists, the company was found liable. The company was also found, and this is why they got sued, to be promoting practices that caused fraud. So there's a shared responsibility between the therapist and the company. They both had the same legal and ethical parameters applied to both. So to say that there's some distinction between them is not correct. Legal guidelines for practice, whether your boss is a non-therapist or not, they are directing therapists to do certain things. They are just as culpable legally as you are as the individual therapist. So to say there's different standards is not accurate. If you've ever spent much time with a compliance officer who's making sure you're not violating HIPAA, that compliance officer might not be a therapist. They could be a nurse. They could be a non-medical person sometimes. They still have to make sure that that legal parameter is not violated by their non-therapists in the company, the whole company as a whole as well. So to say there's some different standards is not accurate. So when I brought up the RAI manual the other day in a video, and I talked about the fact that we have the right to say yes or no to group or concurrent, the company is expected to legally require that as well. It's the individualized plan of care, whether they're therapists or not. Anyway, clarifying one question, and I'll go on to another one in just a moment. Anyway, take care, God bless, and have a great day.